Good morning, everyone. I don't know how to follow that. That was really quite kind. Thank you, Steve. So this morning, we're going to have a talk about everything that's happened in the past 2 years since I last spoke with you. And as Steve said, it's the slides I gave here in 2016, they're unrecognizable. We've had so much happen in our work, so much happen in the world. And I thought that today might be a good opportunity to just sort of pull back and look at the bigger picture and see what can we do outside the code level to sort of get things back on track. So who am I? You can find me on Twitter at WebDevLaw. I am a tech policy and regulation specialist. That means I work to build bridges between coders, developers, digital agencies, projects, and policymakers and legislators. I used to be a web designer, and then I saw the light. I'm an active member of the WordPress.org core privacy team, working to create stronger privacy standards for 33.4% of the sites on the open web. I've also recently helped to set up a working group of the privacy teams working across all the major open source content management systems, so Drupal, Joomla, WordPress, Umbraco, so that we can create a better standard of privacy for, I think, something like 60% of the sites on the open web. That's a really rewarding initiative to be a part of, and I was actually selected for the Mozilla Open Leaders training program to help support that group, so they've got me very busy. I also do a lot of work on accessibility law, and this year I've been kind of head down in Brexit. I'm actually grateful to this conference for getting me out of it for 2 days. So if there's any way I can help you and your companies and your projects with any of that, you are welcome to hire me. And I will say that I'm not a lawyer, and none of what we're going to discuss today should be taken as legal advice. As Steve said, I spoke with you 2 years ago, and I was scheduled to be here last year. And very shortly before the conference, I got completely blindsided by a pretty horrendous, life-changing personal emergency. And it was the first and only time I've ever had to cancel out of a conference in my life. So it really does mean a lot to me personally to have come through it a year later to be with you today. And if you haven't been through an experience like that in your life, you will. And it was a good reminder that things always don't work out as we planned. Things you've put your entire adult life into doing and achieving can fall apart in the space of a morning. And sometimes when I look at everything that's happened in online privacy, online ethics, the world around us in the past 2 years, I feel like that's what happened to me is applicable to what happened to you. Somewhere along the line, we lost control of our own craft. We lost control of our own work. Things we used to hold dear were taken away from us. It has been precisely 0 days since a privacy scandal. The latest one bubbled up literally during dinner last night. I thought it was the other Facebook thing. It's a new Facebook thing. It's the Facebook crisis du jour. Just since I spoke with you 2 years ago, so many scandals and incidents have come out, not constrained to, but largely around the mobile space. We had the Cambridge Analytica scandal, which I'm sure you all followed, when game apps shared with people's friends turned out to be payloading the gaming of an election. We had the recent study by the Yale Privacy Lab and the French Exodus Privacy Group that showed that 75% of apps contain ridiculous amounts of trackers and questionable permissions. We've had things like research showing that many apps contain Facebook analytics kits which send information about you to Facebook the minute you start up the app, even if you don't have a Facebook account. I very much consider my role as one of a diplomat. I don't want to push people apart. I want to bring them together. And that involves talking to people, talking to different audiences from different perspectives, and learning what we all understand about each other so that we can move forward together. And I speak with a lot of full-time data protection professionals, data protection officers, data protection lawyers, privacy lawyers on both sides of the Atlantic about where they feel the problems lie in all of these scandals and incidents. And I hate to tell you, but they don't say very nice things about you. I've heard you developers called lazy. I've heard them call you ignorant. I've heard them call you unprofessional. I've heard them call you useful idiots, that you're all foot soldiers doing Facebook and Google's bidding for them in your enlightened ignorance. I don't believe that about you for a second. Okay, I've seen some of you guys in the pub, but I don't believe you're lazy. I don't believe you're all part of some global conspiracy to do Mark Zuckerberg's bidding. I think you're pretty awesome. And the reason I think you're pretty awesome is because you are people of enormous power and influence over privacy on the web. The decisions you make in your projects, in your workflows, in your code, can help protect people from the misuses of their data by people who would use that data to hurt them. The most amazing thing you do as a developer won't be an app with gazillions of downloads or the latest feature. The most amazing thing you ever do will never be heard about because it will never happen. Because you'll have done something to prevent a scandal. You'll have done something to prevent data from leaking. You'll have done something to prevent people from being hurt by the abuses of their data. That is real developer superpower. So how can you, just people sitting in front of a laptop bashing some code, be a part of a movement? How can you, working in your projects, in your companies, in your organizations, individually and together as professionals, reclaim mobile development from those who have abused it and continue to abuse it for their own ends? What I'm going to share with you is 3 lessons that I have learned from being on the road a lot in the past 2 years, working with groups, working with projects, working with individuals, working on the other side, working with lawyers and privacy advocates, about where I feel the 3 areas are where we could all make a difference working together. The first is kind of obvious, but it's to understand each other. And I have to hold my hand up here and admit that this was my biggest fault. This was the biggest mistake I made. I didn't understand who I was speaking with. I didn't understand where we were all coming from. I do now, and that's what I want to share it with you. Software, whether it's an open source content management system, a JS library, or a mobile app, it's made by those of us who show up. And the thing is, we don't have a clue about each other. People who work in the same teams, whether that's in the same room or distributed on Slack, can work with each other for years and never understand each other. Because we have very different cultural approaches to privacy. For better or for worse, most of the work we do is transatlantic. It's in Europe, it's in the United States. And these two are quite literally an ocean apart. We are in Europe, for now, sorry, and in Europe, we have a certain cultural approach to privacy. We hold privacy to be a fundamental human right. We hold that personal data belongs to the subject. It belongs to the person it is about. We have a culture of opting in, which is, you cannot use my personal data unless I have given you permission to do so. We have a culture of constructive work through regulators, with fines or court action a rare last resort. We have an increasingly resourced and efficient data protection regulator, as all European countries do, which deal with these on the civil level so that you don't have these sort of Americanized lawsuits and see you in court things. And we very much have a culture where people trust governments and fear businesses. This is the complete opposite of the American cultural approach to privacy. That approach holds that free speech, not privacy, is a fundamental human right. And in court action, privacy is very often held to be an impediment to free speech. That cultural approach also holds that data belongs to the website or service owner. If your company has data about someone, it's yours, not theirs. There is an opt-out culture, which is they hold the right to take your data and you have to ask for it to be released later on. They very much have that see you in court culture of adversarial courtroom litigation because they don't have regulators. So court is the first resort. The lawyer is the first resort. And completely opposite to the European culture, people fear governments and trust businesses. That's not to say Americans view companies as benevolent, but they genuinely fear government intervention more than they fear the worst abuses of the worst businesses. So these cultural differences we work with were born from very different historical approaches. The European historical approach to privacy was born out of a collective and social approach. We hold that human rights come first and individual rights come second. And that's because we've learned the hard way. We have a pretty horrendous legacy. Last year, in the space of 6 weeks, I spoke in Northern Ireland, the Netherlands, and Serbia. Those are 3 places which have had actual genocides. They have had the liquidation of civilian populations. They have had attacks on people. They have had persecutions. They have had civilian warfare because of who people are. That is why we take this historical approach. Our approach is a form of atonement. Our approach is learning what we did wrong the first time and doing what we can to make sure it doesn't happen again. But they've never had that in America yet. They have an individual approach that holds that the individual comes before the human rights. This is born out of what's called the East Coast Puritan legacy, which, if you think of the settlers in the colonies on the East Coast in the 1600s, very much held the belief that there is no private life. Everything you do should be public. And if you want to keep something to yourself, it's probably because you're a sinner. But then that crashed into the West Coast frontier legacy, your cowboys on the open range, which believes in the freedom to do whatever you want, whenever you want, without your consent. The world is yours for the taking. When that crashes into the nosy Puritan mentality, it's kind of ugly. And those historical approaches led to very different legal approaches to privacy. In Europe, we hold that privacy is regulated through hard law. I spoke with you 2 years ago about GDPR. That's how we do it here. And that's one overarching law for all member states and sectors. We have data protection regulators like the ICO. If you work in Europe, you'll have your own. We hold that those privacy rights are not tied to citizenship and nationality. If you're a Canadian sitting in this room right now, any data you're dealing with right now, this applies to you. You don't have to prove where you come from. You don't have to prove you're a citizen. It applies to you if you're physically on the ground, or even not, as we'll see later. We have privacy as its own law. It is its own set of disciplines and statutes with its own lawyers, and litigation is the last resort. You don't see things going to court because we have all of that in front of us. Again, completely opposite of the American approach, which holds that privacy is governed through soft law. They don't have any overarching data protection law. It's a piecemeal approach across sectors and states. You've heard of COPPA, about children's data. You've heard about HIPAA, about health data. You may have heard about the California Consumer Privacy Act, which comes in later this year. But they don't have anything like GDPR. The way your data is handled depends on where the person was when that data came up. So because they don't have a federal privacy law, they don't have a data protection regulator, because you can't regulate without something to regulate. They are starting to talk about a federal privacy law. I think they're going to have one in maybe 2 years. And you're going to be all bloody thankful that you listen to my GDPR talk then, because you'll have to do it all over again. But for now, they don't have anything like ours. And the legal approach is very much tied to citizenship and nationality, which is why you have people going apoplectic saying, GDPR, why do I have to follow that? I'm in California. But they don't understand that it's rights-based, it's citizenship-based there. Privacy is a very small set of its own law. Most of it has been shoehorned into other things. So the closest thing to a data protection regulator you have in the States is the FCC, which is the Federal Communications Commission, which was set up to deal with things like radio waves and who gets to license a radio station. So they're still shoehorning issues of online privacy in 2019 into basically stuff dealt for the telegram era. So it's a subcategory of contract, tort, or even property law. And of course, see you in court, sue first, ask questions later. I have explained all these details about our legal, cultural, and historical approaches not to drive you apart, but to help you understand how the people on your team, in your company, in your project think, because we all come to the table with a different understanding of what privacy is and how it works. And we've never understood our differences, much less acknowledged them. So what's the result of that? How are these privacy scandals born? This is the part where we become culpable. but because we don't understand our differences, we structure our work with different cultural approaches to privacy. We write our code with different legal approaches to privacy. We assume everyone we code with works and thinks like we do. So we create the open web with no common standard or understanding of privacy. And we fail to do everything we can do to protect the people and the data. And we don't learn from our mistakes, or at least we didn't until this talk, because now you know that you have to do better. So that's my first lesson for you today, that you have to understand where your team has come from on issues of privacy and culture and ethics and values and legacy before you can know where you're going. So where are you going? That's my second lesson for you today. The second thing we can do to reclaim our craft from those who would abuse it is to hold ourselves accountable. You may have seen this quote. I've taken it slightly out of context, but I won't later. Stay tuned. That the era of move fast and break things is over. The era of act first, ask permission. I don't remember the quote. It's done. It has to be done. But how do you do that in practice? So I'm going to give you a few practical tools you can use today, tomorrow, right now, in your work, in your studios, in your code, in your projects, to help be more accountable to yourselves, to regulators, and to the people in your data. The first is the Privacy by Design framework. It's a non-regulatory development framework devised in Canada in the 90s. And it's remarkable because if you look at the document now, you would think it was written today. It's brilliant. It's timeless. Privacy by design, the principle of it, was incorporated to GDPR as a requirement. You have to be doing this now. I'd encourage you to review your existing projects for good PBD practice, retrofit if you need to, and make this a part of your development workflow going forward. I've written a very long guide to it at Smashing Magazine, which you can read on your own time. I'll share the slides in the Slack later. So what's the Privacy by Design framework? It has 7 principles. These are all incredibly obvious common sense. You may be doing this already. You may be doing some of it. The point of this is to think of it as a holistic framework. PBD holds that privacy must be proactive, not reactive. You have to anticipate privacy users before they reach the user. Don't put plasters after the mistakes have been made. And privacy must also be preventive, not remedial. Stop the silly issues from ever happening in the first place. Privacy must be the default setting. The user should not have to take actions to secure their privacy. They shouldn't have to flick a switch, choose an option, go into settings to activate their privacy, and God forbid they should not have to pay a premium, buy an add-on. It should be default. Consent for data sharing on anything should not be assumed. Privacy should be built into design as a core function, not an add-on, hence work on content management systems' core privacy teams. It should be positive sum. What that means is the Privacy by Design framework seeks to avoid dichotomies. There's no trade-off. There's no trade-off between privacy and security. There's no trade-off between privacy and service offering. You can have both. You can do both, but you have to have a healthy respect for the user privacy. It should be end-to-end. That's about life cycle protection. Data collection, data minimization, data retention, data deletion. Collect the bare minimum you need, use it for the minimum purpose you need, store it for the minimum time you need, get rid of it when you don't need it anymore. PBD and the way you deal with privacy should be open. The things you do should be transparent, public, visible, and publicly accountable. That means your privacy notices, that means your development principles. Nobody should have to go through a regulator, file an FOI to find out what you're doing with their data. Nobody should have to get you in front of the House of Commons or Parliament to find out what your principles are. And it must be user-centric. Granular privacy options, maximize privacy defaults, detailed privacy information notices, user-friendly options, clear notifications of changes, because it's not about you, it's about the people. The ICO, which is the UK's data protection regulator, has a couple of really good questions on their website. They've really made an effort to increase the resources available. They have some questions to check yourself on PBD, and they're common sense, you know. We anticipate risks and privacy invasive events before they occur and take steps to prevent harm to individuals. That means the bit where you sit around a table and ask really uncomfortable, ugly questions. What would happen if this data was misused? What if we have a rogue employee? What if Facebook can't be trusted with the analytics kit we're using? When we use other systems, services, or products in our processing activities, we make sure that we only use those whose designers and manufacturers take data protection into account. That means being really careful about who you work with, whether that's a code library or a partner organization. Because if something happens under the new framework, you're both accountable. If you followed everything to the letter, but you partnered with a dodgy subcontractor, guess what? Again, common sense. So how do you get started on PBD within a specific project? You do a document called a privacy impact assessment. It's a living document which must be accessible to everyone from your board level to the lowest coder down. It's where you document what you're doing on a project, why you're doing it, and what you've done to identify and mitigate the risks. And you do this before you've ever done a line of code. You do this halfway through the project. You do this when you're changing the project. You do it towards the end of the project. The article I wrote on Smashing Magazine has some good prompts to get you started on a PIA. There are templates available, but I don't want anyone to ever think in terms of a template mentality. It's not a tick box, it's not a checklist. Get your prompts in order, but adapt it to your needs. I would recommend adapting a PIA template to your projects, to your companies, to your ways of working, and use them all the time. The areas for those general prompts would be questions about data collection and retention, subject access rights, which is how people find out what data you hold about them and how you're using it. Legal, have you covered your bases on all the legal issues in the places where you do business? Your human and technical security, who has access to this data, why, what do you do to protect it? The risks, and I'm going to flesh this one out into example, personnel, staff, and contributors. This goes beyond the sort of human and technical security about who has access to your data. This is about what you know. This is about, to go back to my first point, the knowledge you bring to the table. Because, God forbid, but in the event of a question about your company's data practices, a data breach, a scandal, the regulator is going to come to you and say, can we please see a copy of your privacy impact assessment? And if your response to that question is, what's a privacy impact assessment? You have two problems. But one of the things they're going to look for in the event of a concern about your privacy practices is, what do the people working on the project know? Who's that? Who has access to the data? What data protection training have those individuals received? What security measures do those individuals work with? What data breach notification and alert procedures are in place? What procedures are in place for government requests? So this is where you're thinking ahead to when things go horribly wrong, and you don't have any of these answers in place. That's not the time to think about those questions. The time to think about them is now. To flesh out that second question, what data protection training have those individuals received? In the event of a concern, an angry regulator is going to want to know if the people who worked on your app are competent in the European Data Protection and Privacy Framework, any industry or sector regulations you have to work with. So I'm presuming Compare the Meerkat would be regulated by the Financial Services Authority. There may be additional financial regulations on data and privacy you might have to follow over and above GDPR. And of course, a big company like them will have that in place through their legal team. Smaller agencies, not so much. So if you're subcontracting to work on something like a health app, you need to make sure that you're following any regulations to the medical industry in addition to GDPR. Development frameworks and methodologies. GDPR doesn't tell you what to do or how to code, but it tells you decide what you're doing, stick with it, and document it. Document that training in your HR records. Do occasional inductions and refreshers. That's something I do. I come into teams and I give them training on GDPR. I give them refreshers on how things have changed. Because again, when the proverbial hits the fan and you don't have any answers to these questions, you've got a much bigger problem than a data breach. So those are just 2 tools to get you started on being more accountable to yourselves, to regulators, and to the people in the data. Review what you do, review why you do it, review who does it, and review what they know. Document it, document all of it, document it all the time. Document it or it didn't happen. So we've talked about culture, we've talked about tools, and now we're going to talk about something that I've just really become cognizant of in the past year. Because we're all talking about ethics. Xavier gave a fantastic presentation. I was looking at your slides on the train yesterday. They were brilliant about ethics. And it's wonderful to me that everyone is thinking in terms of becoming more ethical developers, becoming more ethical projects, becoming more ethical companies. But I need to tell you that ethics aren't enough. And there is a tipping point where the discussion about ethics becomes something it's not meant to be. I used this quote out of context earlier: the era of move fast and break things is over. The full quote is, the era of move fast and break things is over. It's intellectually inconsistent to preach about a disruptive billion-dollar vision and imagine it as being free from regulatory considerations. It fascinates me how often entrepreneurs lack a basic grounding in the regulatory hurdles they may face. Right now, ethics are really important. They're trendy, they're kind of sexy. Talking about ethics makes you look really on brand. Talking about GDPR and CCPA makes you look like a geek who has no friends and everyone wants to avoid you in the pub. But they're 2 sides of the same coin. Ethics give us the tools to take a critical look at how we make decisions and to determine whether they grant users agency, rights, protections, and the opportunity to flourish. Yet ethics do not stand alone. They merely lay the foundations for larger frameworks of social contracts encompassing policy, governance, law, and human rights. This is a quote from an article a friend of mine have recently written, which is being published any day now. I was hoping it would have been published by now. And we'll come back to it. Because what we're talking about in this article is something called ethics washing. Ethics washing is a recognized phenomenon. And it's what happens when ethics are devised and adopted in lieu of a healthy approach to privacy laws and regulations. This is when everyone starts talking about ethics, not to complement privacy laws, but to get around them. Because if you're talking about ethics, you must be pretty awesome, aren't you? So when Google was found shoving hundreds of thousands of people's medical records into the DeepMind AI system without their knowledge or consent, they said, but we're trying to help the NHS. Who wouldn't want to help the NHS? That's ethics washing in action. Mr. Zuckerberg, it's been, half hour since I last mentioned you, coming out the other day with this bizarre 4-point editorial on how Facebook would like to jump on the ethics bandwagon on privacy, and the Information Commissioner herself came out with a cracking mic drop and said, if you really believe that, how about paying your £500,000 fine for the last privacy law you violated? Ethics washing is when people hijack the ethics debate to use it for something else. It's the opposite of good ethical process, and it actually increases your governance risks to your projects, to your companies, because it creates this, almost this race to the bottom, where everyone wants to adopt the sort of vaguest, airy-fairiest, weakest, and sometimes actually privacy-invasive practices possible to code it in some sort of value statement and then frame those gestures as some sort of laudable achievement. It lets villains play the hero. But from my perspective, it also signals a belief that projects are above the law. Because, yeah, there's that privacy law we ignored since 1995, but here's our new ethical code for dealing with people. To which I would say, if you look at a lot of the scandals that we've had to deal with in our work, 75% of them were actually about not following the privacy law that had been there since the 90s. So I don't like this trend of projects acting like they can mark their own homework by devising a code of ethics as a substitute for healthy legal compliance. But the worst thing about it is it shifts the moral responsibility for safeguarding privacy from the project to the user. Privacy law has your back. A code of ethics does not. A privacy framework is externally accountable, has a regulator, you have rights, you have recourse. What recourse do you have against a code of ethics cooked up at a corporate retreat? You don't. I don't want to sound like I'm hostile to the ethics trend. I'm not. I think it's wonderful. But I have to put my hand up and say how badly I'm seeing it being abused by so many people right now. Ethics washing isn't something I made up. It is an academically recognized phenomenon. There's a professor at Vienna University called Ben Wagner who's done fantastic work on it. And he's put out 6 tests to safeguard and check yourselves that any work you're doing on ethics is not in fact ethics washing. Are you engaging externally? You know, this can't be something you cooked up yourself. It has to be externally accountable. And that means oversight. That means someone challenging you on it. You've got to be clear on why you've made these decisions. You have to pin your framework to non-arbitrary external standards, whether that's a company or not a company code of ethics, a regulatory body's code, or privacy law. There must be a clear indication that selected ethics do not substitute for fundamental human or citizen rights. And there must be a clear statement on how your ethics relate to a legal framework. And what do you do when they're in conflict? That sixth question in this test is almost impossible to pass. That's your tripwire, as it should be. As we've said in that article, we owe it to ourselves and our users to use ethics the right way, to help shape the privacy rules and regulations which govern our craft, to differentiate between best practices and the rule of law, and to ensure the paths that we carve for our users lead to human flourishing. And we owe it to ourselves to understand the important role ethics can play and learn to use them to build better futures rather than exploit the trend to use them as a loophole around the law and the rights it grants our users. I want you to all think about ethics every day in everything you do, but I also want you to think about privacy law. I want you to think about the ways you will constrain yourselves and your projects and the people you work with from committing abuses which can be exploited. The friend I've written this article with is called Morten Rand Hendrickson. I want you all to watch this conference talk that he gave last year at WordCamp Europe in Belgrade. I was in the audience. I was a mess. I watched grown men weeping at this talk on ethics and development and design, and it's the most amazing thing you'll ever see, and I'll share this later. That's my 3 tests for you and tips on how to reclaim your craft, take back control, from people who would misuse the data we hold and misuse you, exploit you really for their own ends. I want you to better understand each other and the people on your teams, the people on your Slacks, the people in your projects, what you all understand, what you bring to the table, where you're all coming from, so that you can understand where you need to go together in terms of holding yourself accountable through toolkits, through frameworks, through practical action to do something meaningful. And I want you to remember that ethics aren't enough. Please do everything you do in an ethical manner, but make sure you're backing it up with something. And I'll repeat what I said earlier, because I really do believe it. You are people of enormous power and influence over privacy on the web. The actions you take within your projects, within your apps, within your companies, however small, can protect the people in the data from those who would use that data to hurt them. Let's work together to reclaim our craft. That's the end of my talk, but I hope it's the start of the dialogue. I want you all to talk to me today about what problems you're having in your projects, in your companies, what I can do to help you move forward. My train is until 5 o'clock, so please get me for a coffee, and let's keep the dialogue going after the conference. Thank you. Thank you.
Does anyone have any questions? Yes.
I
So
can't see you.
No, yeah, I was up there yesterday. You can't see anything. Just pretend. So I'm from the USA, and I've been looking at GDPR sort of externally and thought, yeah, I think it will come to the United States in
Yes.
some way, shape, or form.
Yeah.
I'm less optimistic than you are. I think in the 5 to 10 year time frame, not 2 years, even though that'd be great and brilliant. But as somebody looking at things from your perspective, what do you think might be the biggest barriers to adopting something like that in the United States?
So, first thing I'm going to say is you have a practice run coming up, which is CCPA, the California law. If you did what you needed to do to come into healthy compliance with GDPR, you're about 80% of the way to CCPA. So CCPA is something California has put in, and it applies to any company over a certain size and turnover which holds data on Californians. So if you're in Florida and you have a certain amount of Californian customers, you have to do that. And it does two things. It sort of proves why GDPR was a really good set of standards to follow, but it also sets the stage for that federal privacy law. Because it's great that California's passed a law, and it's great that Vermont wants to pass a law, and we can go on. But what's going to happen is you're going to have 50 laws. And this is why we have one law in Europe for 500 million people. So the move towards a federal privacy law is as much about making things easier for yourselves, because even you know, the libertarians and the Republicans who have traditionally resisted this stuff tooth and nail agree. We can't have people trying to figure out which one of 50 laws to follow. So that is one of the answers to your question. It's that there's that resistance to any legislation at all. But it is the direction of travel. And I think people are finally coming on board with the idea that we've got to do something, and better to do one thing than 50 things. So there were some hearings held in the House and the Senate last week. There's lots of work going on in the shape of an eventual federal law. There's lobbying. I have an entire physical notebook at home devoted to researching all the draft statutes and frameworks. There's 30 of them. If I didn't have to deal with Brexit, I could do nothing but look at US federal privacy law. It's complex, but it's coming. So what I would advise you is to keep up with CCPA, keep up with GDPR, and then when a US federal privacy law comes in, you'll be almost there already. But the obstacles are, as I said, those cultural, legal, and historical issues, and the sheer amount of effort in doing one law as opposed to 50. But I'm happy to talk to you more afterwards.
Thank you.
Anyone else? No? In that case, please show your appreciation for Heather.
Thank you very much.